Tutorial for filing a motion to restrict public access and redact document. U.S. Bankruptcy Court, Northern and Southern Districts of Mississippi. Privacy requirements under federal law. 11 U.S.C. 107. With certain exceptions, every paper filed on the docket of a bankruptcy case is a public record open to examination. Exceptions. Documents filed under seal or restricted access by protective order. Documents containing certain personal identifiers. Privacy requirements under federal law. Section 205(c)(3) of E-Government Act of 2002 requires federal courts to establish rules to protect private information contained in documents electronically filed with the courts. Federal Bankruptcy Rule 9037. Federal Bankruptcy Rule 9037. Generally, a filing with the court that contains certain personal identifiers should include only the last four digits of a Social Security number or taxpayer identification number, the year of an individual's birth, the minor's initials, and the last four digits of a financial account number. What happens if private information is inadvertently included in a filing? Generally, all documents filed with federal bankruptcy courts are publicly accessible through the Public Access to Court electronic record system, unless filed under seal or restricted from public view by court order or rule. Any personal identifier not properly redacted before filing is accessible to the public unless and until the document containing such personal identifier is restricted from public view and replaced with a properly redacted document. Facts about publicly filed documents that contain personal identifiers. The clerk of court, custodian of court records, does not have authority or responsibility to redact documents filed with the court. The responsibility to redact a filing rests with the party that made the filing with the court. See Committee Notes 9037. A party must file a proper motion with the bankruptcy court to request redaction of a publicly filed document. Who can redact private information inadvertently included in a public filing? The clerk of court does not have authority to redact a publicly filed document. The clerk of court has authority to restrict public access pending a ruling by a judge when a party files a proper motion. See Mississippi Bankruptcy Local Rule 9037-1. Thus, a party that files a document disclosing personal identifiers will be responsible for filing a properly redacted document. How does a party request redaction of a publicly filed document? 1. Using each court's local forms, file a motion and proposed order to restrict public access and redact document. Note, local forms are available on court websites. 2. Use proper ECF event, Southern District, Bankruptcy, Motions, Applications, Restrict Redact Document. Adversary, Motions, Restrict Redact Document. Northern District, Bankruptcy, Motions, Applications, Redact, Fee per case. Adversary, Motions, Applications, Redact, Fee per case. 3. Pay $25 filing fee. Motion to restrict public access and redact document. Motion should seek authorization to file a properly redacted document. Request that clerk be directed to restrict public access view of the unredacted document and include as an attachment a proposed order granting the motion. Moving party must serve notice of the motion on debtor, any person whose personal identifiers have been exposed, case trustee, if any, and United States trustee. If court grants motion, appropriate party should file a properly redacted document.